Happy New Year. We last met in November. I am sure all of you had a good Christmas and a Happy New Year. I'm happy you are here once again. And we are happy and excited to have Council Bogere once again to take us through some very important issues to do with our preparation, winding up of our estates and other goodies which we take time to make during our lives. Formally introduce the guest when I'm sure that he's on. At present, I'm not quite sure we have him. In the meantime, we can remind ourselves a few things about the topic. Yeah, Purposeful Aging actually thought that we needed to have a little more about laws and everything that goes with making wills and terms which we come across, like powers of attorney and all that. As you all know, life is full of blessings, challenges, and changes over the years. We work hard to build something meaningful, whether it's land, a house, a small business, or even personal belongings that carry deep sentimental value. These are not just assets, they are the legacy we leave behind for the people we care about the most. But as we age, we often start asking ourselves important questions. You spend the whole day worried, thinking about what will happen to your property when you're no longer here. Will your children or loved ones be taken care of? And how can you ensure that there is no fighting and confusion over what you leave behind? That's why Purposeful Aging has once again asked and has been honored by Council Bogere to come out and tell us more about this process. Hopefully we will all interact actively as usual. At the back of our minds, have things like your family situation. Are you having a united family, United Nation family like we joked last time? Do you have assets? Do you have land? Do you have house? Do you have livestock? Business? Do you have special wishes you would like to be sure of they are fulfilled when you rest? And do you have children who need guardianship when you rest or when you're not there? How about those customs and traditions? How do they influence what you have, your property, and your wishes? And there are so many legal facets which we need to be sure of, which we need to incorporate in our lives and culture so that we make a will with this in the background. Today, we are fortunate to have Council Bogere once again. And from our last topic, we all know that he is not going to use complicated legal terms or legal language. And all this is usually put in a language basic and helpful, a language which we feel confident, which will make us feel confident about taking the step of making a will. Remember, making a will is not about preparing for death. It's about ensuring that your loved ones are protected and your hard work is honored for generations to come. He will explain everything in simple language, and you have a chance to ask him questions that have bothered you for a long time. Questions resulting from his talk where you are not very confident. Please do ask him. Feel free to listen, take notes, and ask questions. This is your time to get clarity and peace of mind. Just for a quick word, Council Bogere is now with us, and I would like to repeat his introduction for the sake of those who were not with us last time. Council Bogere is Council Robert Ali Bogere holds a Bachelor of Laws degree from Makerere University and a postgraduate diploma in legal studies from the Law Development Center. He has served in the Ministry of Justice and Constitutional Affairs for more than 15 years. And this was with the Directorate of the Administrator General. Council Bogere is an external examiner at the LDC, Law Development Center, Barcos, as well as a course facilitator at several universities. He's a facilitator and a part-time, he's been a facilitator and part of the team that developed the curriculum for retooling retiring civil servants and career transitioning public servants. And this was at the Civil Service College in Jinja. Council Bogere has played a lead role in the amendment of the succession laws. He's always ready to exchange ideas and share knowledge, and that is very, very good. This is what we really need as Ugandans, most of us. With that short introduction, I would like to greet Council Bogere, good morning, and just to let you know that you have with us older adults. Some of them are blood relatives, some are just caregivers, and others are the ones being cared for. All of them are ready to listen to you. Some have spent their lives working in Uganda, the host country, in Uganda, their home country, and others have made families abroad. They've made assets abroad. Then there are ladies who are involved in various business groupings, which are legally not formal. They are informal groupings like circles, but they do have all their money and assets in such groupings. So I hope that all of them are ready to listen to how they can prepare these assets and various properties before they finally rest. Council Bogere, we are ready to have you, and after your 45 minutes, we shall have questions and answers. Otherwise, you're most welcome. Good morning, and the floor is yours. Thank you.
Hello. I hope you can hear me.
Yes, we can hear you clearly.
Thank you very much, listeners. I'm sorry, I was a bit late. I had to fight off a young man who wanted to be in the same room with me as I play on my laptop. That's what he thinks. Uh, I've been away for some time from home, so I came back yesterday. So he wants really to be here. But we are good. We are good to go. Today, of course, the time is tough to be able to talk about wills, trusts, and everything in between, but I will give it my best shot. Uh, I always tell people when I'm talking about this subject that many people, when you ask them, especially people who believe in God and all that, and you tell them, how many of you want to see God? They all put up their hands. And then you tell them, how many of you know that you have to die before you go to see him? Then you get a chill in the room. I'm not saying this about the fact that when you make a will, you will die. It's a common misconception in this country that when you make a will, you are gi- giving bad, you are putting bad luck on a mark on yourself, and that you will die. So you put it to people that, please, when I go to do these talks, for instance, at the Civil Service College, I tell them that maybe we can make our wills tonight and we wake up tomorrow and see which one of us would have died. It's just a joke, but to make people realize that in every, let me say, serious country, even when you hear in the West, you hear of people who are on drugs, you hear of people who have addictions to so many other things. Then you hear, Michael Jackson died, he left a will. So and so died. People in their 30s, they left a will. It is us here who have yet to develop that habit. In most Ugandans, probably 10% only are the ones who make wills, and some of them who make those wills also make them with faults. You can read an average Ugandan will. The average Ugandan will is a person quarreling with everyone. Is a person whom you hear he doesn't want to die. He doesn't want to leave his property behind. And he makes a will and he gives orders about plates, about saucepans, about blankets, and saying, when I was sick, so and so did not come to visit me. This one, when I die, should go away. That's the average Ugandan will. A will of a person who is fighting against the entire world. So we want to demystify the will making process, and we understand that I'm not here to tell us that. As you hear, my name is Robert Ali Bogere. I became a Muslim when I was at Makerere University. In Islam, I'm not preaching, but I'm just giving a scenario. In Islam, whenever the Quran talks about death and life, it starts actually with death, because death is more certain than life. Before you are born, there is a certainty that you will die, but there is no certainty that you'll be born alive. So when I give these talks to groups, people start saying, if I die, God forbid. No. Me, I tell them, no, God will not forbid. We will all go. So the best thing to do is to prepare for that eventuality. I'm not here to make people sad, but to make people actually realize that death is something we cannot control, but we can control its consequences. You can't control the fact, you can't fear the fact that you will die, because you are alive because you will go one day. So as a certainty, let us make wills. The Baganda have a proverb which says, ofundako mubinga mweru. It's, or the Wazungu, to give it the Wazungu way, is if you are to eat a frog, eat a fat one, if I can say it that way. Since we are all going to go, the best to do is to prepare for it. The best to do is to prepare for what comes after it. It's best.
Hello. Council, we've lost you.
Can you hear me?
No, we can't. We just lost you a few seconds back.
Okay. This Wi-Fi of I have a Wi-Fi thing, but sometimes it does that. Today we must understand the importance of writing a will. If you don't have a will, I hope that tonight you can draft your will. And then you also go and tell other people what is good about writing wills. Or you go back to home and you rectify your will. So because of the time limitation, let me run into it. These are the most important things to note while you are writing your will. First, you should be at least 18 years old, because that's a person who is an adult. You should be of sound mind. As we said, we are going to explain these things so that they are basic to everyone. Soundness of mind can mean several things. It means you must be in control of your faculties. You are not under the influence of alcohol to such an extent that you think driving on the people who are driving on the right side of the road are the ones who are wrong. You must be not under the influence of alcohol, of any intoxicant, drugs, such that they take away your freedom or alter your natural affections. So soundness of mind is anything which can take away your freedom of mind, your control of your mind. It can be a chemical, can be something you imbibe, you drink. But there is also another way of controlling your mind, which may not actually be a drug or something you have ingested, but you must not be under the influence or control of any person that takes away your freedom or alters your natural affections. I was in Nakasongola one time, and a man wanted to marry a second wife, and the RDC of the place said, I will not allow you to marry a second wife unless you make a will and give all your property to my sister, who is your first wife, my sister and her children. So the man came to me and said, how do I want to marry a second woman, but the RDC here is the brother of my first wife, and I have been ordered to make a will because the wife he wanted, the second woman, was also from Nakasongola, and the marriage was supposed to also be in Nakasonga. So RDCs, they claim that they are the presidents of the districts where they are. So everyone feels marriage will not take place until you make a will. It is a will. If you are to make it, that's a will which is you are being forced to make. So you are not in control of that will making process. So if you made a will like that, it will be liable to be set aside. Wills which are made like that, in that kind of times, lose focus of the people who are supposed to share in your estate. Another thing we must notice that there are people who have on and off mental issues. In law, we call them lucid intervals. There are people who have mental challenges, but they may be seasonal, they may be periodic, they may be for a short period of time. That person can make a will in the period when they are not in that kind of condition. The clearest example I can give is a person who suffers from epileptic seizures. If that person has made orders for the will to be typed, and it has been typed, and let us say that person puts ink on their thumbprint. I'm giving a weird scenario, but it can happen. He puts ink on his thumbprint and he's going to imprint it on the will, and then he collapses. He gets the seizure because it's momentarily, it takes him over. You who are present, you are not allowed to say, since his thumbprint is already inked and this is his will, let us get his, because for us we are rushing, we are going away, we have other commitments. Let us get his hand, which is already inked, and put it on the, and put the thumbprint on the will, because it is his, he made it when he was, no. So although that person can make a will and he has made it actually during the period when he was okay, at the period you are making him sign it, he is not in control of his mental faculties. So it's the same thing with people who have other ailments. I'm not a specialist in those, but there are senile people. There are people who have Alzheimer's. I don't know the difference between Alzheimer's and the other conditions around that. There are people who sometimes forget. I remember a client who would sometimes ask his children, "What is your name? Pose, what is your mother?" There are people who have that kind of on and off. So when he is okay, he can make a will. Of course, now the issue comes to proving the circumstances under which he made a will. That's why sometimes we need witnesses. So for you to make a will, I've not gone into issues of definitions, but we'll go there once we are into it properly. You make a will. A will is a document which we say it has to have testamentary intention. A will is a document which you make intending that document to take effect after your death. So that's what we call testamentary intention, that if I make a document and I give to my wife, I make an agreement and I give to my wife a deed, a chibanja, or a plot of land. That document will have a date, it will have me who has signed it, it will have witnesses. I will not be forced to make it. So all those characteristics are from a will. But this document, like a deed of gift, is a document which I am making to take effect immediately. So a will differs from a kind of a deed of gift, because for the will, it takes effect after your death. That's the intention, that it must take effect after your death. And that is why that will does not control the maker. The maker is free to change his or her will up to the date of death. So a will is different from other documents because for it, it has testamentary intention. Anyone who is incapacitated physically, visually, like people who have lost eyesight, who have lost hearing, who have no hands, all those people can make wills. All those people can make wills. It is not that because you are you. It is not that because you are you are physically incapacitated that you can't make a will. So a good will should have the names of the maker, the names of your spouses, the names of your children and dependent relatives, the date on which you make a will, the description of your property, the description of the property, and the distribution of your property, which beneficiary gets what property. Then you have to, if you want, you can put conditions on your gifts. We'll break it down bit by bit. You have to give conditions for your gifts, and then you have to name an executor or executors. These are the people who will implement your will. Under the new law, the will must have your names, address, and signature on each page. So it also has to have the names, address, and signature of at least 2 witnesses on each page. These are issues which are not yet tested in law, but the law says that in case the names or address of the witnesses are missing on each page, it may become a court issue, and it will be the court to determine if that particular page is a valid page. So what we mean is that previously, witnesses could only sign maybe at the end of the will, after the maker has signed. Now, the new law says, the amendment, that the witnesses must sign and give their address and names on each page. We can understand that the intention was that sometimes people would just scribble their signatures without saying who they were, so it would be difficult to trace them. But I think that requiring that the names and address and signature should be on each page is too much, is an overkill. That's for me. So the will has to have the names of the maker, the spouses, and children. One of the reasons why you have to have your spouse or children in a will is that those are the people for whom your natural affections are geared towards. Those are the people who are ordinarily we're supposed to have natural affections for. If your spouse is not in a will, it could be understood as if you forgot to name her, and it could be a challenge to your will. It's a different thing naming her or him and not giving them property than not naming them at all. A description of your property is key, because we have so many people who have the same names, and I've handled estates where a deceased person called James Mokasa belongs to a family X, but then a family Y comes and claims their property because they also have James Mokasa. So if you can describe your property properly, that can be. There are even people who have children who have the same names as they, and you
Right.
pass on. Hello.
It's okay.
And you pass on, and your child goes and claims the property which is in your names because you have the same names as that child. Uh, Another issue on conditions, you can give child X property with the condition that they pay school fees for another child or another beneficiary. So if I give a condition in my will and I say, I am bequeathing property X to Bogere, he must pay school fees for Robert. If Bogere refuses to pay school fees, he can't take the property. In a deceased's will, because the property is for the owner of the will, you don't pick what you want from it and reject the others. The will is read as a single document. Issues of executors. Executors are people who basically take over your responsibilities. They become you in law. An executor's power. An executor is the person who implements your will. An executor's power comes immediately on the day you die. It doesn't actually depend. It doesn't depend on probate or letters of administration. That's an administrative process. But the law says an executor's power begins from the date of death of the maker of the will. It's different from the powers of an administrator, which begin from the date of the grant of letters of administration. It is very crucial that when the persons that you name people you absolutely trust in this role. The biggest problems we could see in estates of deceased persons in Uganda, people who have left wills, is the role of executors and how they mismanage property. Many executors who, if they are your friends, some of them will have loved your wife if you don't know. Or some of them will have loved your wife and the wife refused and then they hate her for it. And so they come in the estate to fight your spouse. Or they come in the estate to fight the wars of the estate. So we've seen it a lot. I've seen estates where the executors are lawyers and they have messed up the estate of a deceased person. I've seen executors who are every religious domination you are aware of, and they have messed up the estates of the deceased because of taking sides in an estate dispute. So these are very crucial people whom you must take very great care in naming, because they are going to do everything that you have commanded in your will. It's going to be done by them. In a will, in a will, you can, if you want to change anything in your will, you don't actually have to redo the entire will. And it's a very big problem that you find a person, he wants to change his will. The first thing he does is to destroy this one which he has. Then he starts writing a new one. Then he dies in the middle of writing the new one. When all you could have done is to make another document, an additional document, which we call a codicil. It's a document which you can use to supplement on a will, or to modify, or to explain, or to alter any part of the will. If my heir in the original will was Robert, and that's the only thing I want to change in my will. For instance, I have here, he named him my heir, but now he supports another team. I'm giving a joke. For some reason, maybe he's been convicted of crimes which I find abhorrent. I can name a new heir Ali. And so when I make a codicil, I say, I give it a date, I put my names, and then I say, my heir in the old will was Bogere. Now I am naming, I am naming, I am naming Ali as my heir. So that it's a good practice to have the same place. It's a good practice to have that codicil stored in the same place as the will. So when we are reading your will, we will read those documents together. This is a very crucial thing, in that it is essentially the heart of a will. You can only distribute property you own in a will. You can distribute property which is due to you, in the future. For instance, pension. You cannot distribute what does not belong to you. I have seen a will of a whole lawyer, let me put it that way, a whole lawyer who, because he was born, they were born to him and his brother who was mentally disturbed. What the lawyer did, he made his own will and distributed the property of his father in his own will. So if an advocate, a person who knows the law, and this was a senior lawyer, if an advocate or a person who knows the law can even make that mistake. So it is very common. You find the heirs, customary heirs, thinking that the property in which they were heirs, the estate, has become their property. So they go and distribute it. They go and distribute the property of their fathers. You cannot distribute property in which the title lists your names and at least one living person as joint tenants. Many of us when we get married, we we buy land and you put the land in a title which reads you and your spouse's names, and the title is silent. So basically, it has the two of your names. Under the law, that is called joint tenancy. A joint tenancy, a joint tenancy means that there is no title after you die in you. If, for instance, you, the husband, dies, the property remains the property of your spouse. The property remains the property of the other surviving joint tenant. So if you make your will and you say, my half of the house, my half of the land, I am death, which takes away your ownership. So that property ceases to be subject to you, to your interest. Your right dies with you. You cannot make a will. You cannot make a will and distribute it because it is not your property. Another aspect of not distributing what does not belong to you is administrators. If you are an administrator of an estate, if you're a beneficiary, you have a share there. But if you are not a beneficiary, you are just an administrator. But this happens a lot, especially for beneficiaries who are administrators. And he takes it upon himself to distribute the estate which he is administering. I've had, probably in my work experience, around 20 cases where a daughter-in-law of the deceased wants to manage the estate of her father-in-law because her husband, who was the administrator and usually the heir, gave instructions in his own will about the property of his father. So you find a daughter-in-law fighting the children, fighting her in-laws, her brothers-in-laws and sisters-in-law, because her husband usually was the very powerful administrator and heir in that estate. There's another such matter. The daughter-in-law became the administrator of the estate of her father-in-law. When the father-in-law has children who are still alive, so a daughter-in-law is fighting. The daughter-in-law is fighting her brothers and sisters-in-law over the estate of their own father. Right now, under the new arrangement and the new amendment of the Succession Act, you cannot distribute your residential homes. So that's one of the properties, part of the properties you cannot distribute. You cannot distribute residential homes in which you live or in which you and your children and spouses live, unless you give those people alternative homes at the same station, at the same level in life. For instance, you have a home in Kololo and you want to distribute it in your will, you have to find for your spouse who has been living there with you or dependent children, you have to find for them alternative accommodation at the same. So you don't take them from Kololo in the $1 million house and you put them in Nansana in a $100 million house. That's not the same station, if I can put it that way. I hope these provisions get tested, but they have not yet been. Who can be a beneficiary under your will? Living persons. Those are children, spouses, friends, dependents. A beneficiary in your will can also be the government. Since I work for the government, let me campaign for the government. You can make a will and say, I'm giving 10 acres of land for the building of a hospital. It was a very common thing in old wills, but these days we have become more selfish. The wills of people who were from the 1900s up to around 1970, you would find people giving land to churches, to mosques, to schools. It was a very common occurrence. So you can give land to even the state. You can give land to non-profit organizations, faith-based organizations, orphanages. But, and this is a very key issue, this is very restricted. I have had in my life experience, in my work experience, I have had to fight Muslims, Catholics, Protestants, Anglican, and evangelical. I've had to fight even the mama phenotypes, if I can put it that. People who, when a person is about to die, in all faiths, that thing is there. They go there to
Bliss.
see. We all religious groups. So and they can see that they are on their last legs, if so to speak. They encourage that sick person to make a will, and then they read to them their holy book. Most holy books have a lot of scaring terms about the afterlife. So they can tell you, oh, store your property in heaven where the thieves don't steal and the moth don't destroy. Where you are going, there will be gnashing of teeth, there will be fire. So give your property to such and such a group. There's a Muslim community where they they convinced a woman to make a will giving property like nephews and nieces. The same group made one woman give her property in Nalukolongo here. And that woman had a small girl of 14 years old. And they told the girl, you go and look for your father. So, because the law knows that these kinds of people have a lot of control over a person who believes in their faith, the law says if you are to make a will and to give property to a non-profit, to a faith-based organization, to a charity, you must make that will at least 1 year before you die. That will must be dated at least 1 year before your death, and it must have been stored in a place provided for under the law for the safe custody of wills. This is to avoid a situation where they come, ambush you make a will because you are going to die after 2 weeks. So that you can have time to reflect and say, these things that I did, are they okay? So you can leave your property to any person, regardless of age, location, and status. So most Ugandan men have, I have previously told you, most Ugandan men have United Nations families. He can have a wedded woman, a girlfriend, then he can have another one who is semi-official. Then he can have those even himself whom he doesn't know until they come later in his life that, by the way, I have your child. So since you know the complexities of your family, the best option to do is to leave a will and provide for all these people in their different capacities. If you know you have a baby mama, a woman whom you have a child with, provide for that child, even if you don't want to provide for the mother. If you know that you have another woman who is good to you, who has done good to you, who has developed you, but she's not your wife because you are married in church to another one, there's nothing wrong with you providing for both of these women. always said that with examples we give, we usually give examples of men dying because that's what is very common in this country. Now, there are people who are, I call them disqualified beneficiaries, people who are not allowed to take a share in your estate under a will. One of them is the person who drafted the will. You can draft a person for a will for a person because that person doesn't know how to read or write. Because of the power you have and the intimacy with and the confidentiality you have with this person whose will you are making, you have a fiduciary responsibility to this person not to share in their estate, because you can insert your name there, or you can even tell that person, but me, you have not given me anything. Hmm? Is this fair? And the person may feel guilt and it's a kind of coercion and influence to make you also share in that estate. Other people who are not supposed to share in a will are witnesses to the will. Here we've found estates where I found one estate where a man made a will when his father-in-law was present, and his brother-in-law was present, and his wife was present, and they are the witnesses to the will. And he gave every bit of property he had to that woman. And even he said, whatever property I've not be- bequeathed is also for my wife.
Counsel, I think we've lost
So
you.
you are not supposed to take a share in the will making process that you can you hear me now?
Yes, but
Hello?
do you mind repeating
Hello?
that?
Okay, let me repeat it. I was
Yeah.
saying that if you are a witness to a will, you are too close to the will making process. You are
Ah,
too close to that process that the law says you should not get a share in it. So I was saying that if you are a spouse to a person, don't be, even if you are present in the room when the will is being made, don't sign on it as a witness. It is a I was given an example of a will I saw where the will was made in the presence of the father-in-law of the testate of the make of the will, the brother-in-law, and the wife. And the man had children elsewhere, and he never gave them anything. All his property he gave to the wife who was present in the room when the will was being made. And that will was recently, like 2 years ago, in a court in Masaka, because of the circumstances under which it was made. The spouse was the beneficiary in it and also a witness to it. You are also, there are people who will not take a share in your will by operation of law. For instance, if you give your property to your spouse and then that spouse kills you. There was a case some time back of a lady called I think it was called Juvenile Nsenga. There's a deceased person who was called Nsenga, who was murdered by his wife. The wife is now serving time, having been convicted. So in case that man left a will, giving his wife a share in it, and then she's convicted of killing him, you cannot take a share in the estate of a person you kill. It's a very common thing in this country of children wishing their parents dead because the parent is not dying soon enough for the child to enjoy the estate. So if you take it upon yourself, if a person takes it upon themselves to facilitate the faster dying of the will maker, because you have seen in the will a share for yourself, and you are saying, my good life is on the horizon, but this man is not going. So if you push him to die, you will not take a share because you are not supposed to benefit from your own criminal actions. Another ambit of that is I give property to my wife, and then by the time I pass on, we have divorced and they are not married to me. This is a controversial in the sense that some jurisdictions have said it depends on whether you were giving her in her personal capacity or you are giving her as your spouse. In which case, if you are giving her as a spouse, she is not on the time of your death, your spouse. If you are giving her as an individual, she is still an individual. There are famous cases on that. Same thing with children also. If you give a, if you list your children and you give them, and then it turns out on the day of your death that after your death that some of the people you named as your children are not your children. The, the courts have also stated that it will depend on whether you would have given them, even if you did not know that they were your children. When you were raising them, it's a complicated issue, but the simplest bit of it is that were you giving that person as that person, or were you giving that person as your child? So we sit in your shoes on the day you made the will. What was your intention? Was it to give the individual, or was it to give the title that individual comes with? So some courts have said the person will take the property, even if it turns out that they were not your child. But other courts have said no. What was the intention of the maker was to give to his child. Uh, one of the things I do is to see if we can go through what we call the contents of the will, so that we can then finalize our will making process. Is that one, there is no standard format of a will. There is no standard format of a will, but we could say that always begin your will with the title. If it's the last will and testament of, although it's not mandatory, then you declare that you are revoking previous wills. Because it is the best thing is to have one final testament. You declare you are revoking the last wills you made, the first wills you made. Then your marital status and the names of your spouses and the names of your children and the names of your dependents. Second, a description of your property and how you want it distributed. You also provide conditions, if any. Third, a comprehensive disinheritance. They are, in truth, there are people in our lives whom we should not give property. They may be children, they may be spouses, they may be friends, they may even be your parents. And for one reason or another, a very just reason, if the person even sued us, I will repeat that because I'm seeing the internet is unstable. There's a will I handled where a deceased man made his will and said, to my child, Bogere, I have not given anything because he beat me twice. Then he accused me of loving his wife, my daughter-in-law, in public. Then every business I made for him, he drank it. That's the words he used. I called him to visit me when I was in hospital for a year, and he refused to come on 5 occasions. But on the day that he came, he just wanted to beat me and was restrained by the people who were present. Therefore, I give him the following two verses in the Bible. There are verses in the Bible he gave him. Is the fear of God, I think, is the beginning of wisdom, something like. And then respect your parents so that you can live longer. I think there's a respect your there's a verse on parents. I've forgotten. I used to be in it, but I forgot those verses. But there are verses on living longer and respecting parents. Those are the two verses he gave to that man in the Bible. So that is simply don't keep quiet about that child. Tell us that I am not giving him because of XYZ. Don't leave it to a suit where that person can sue and say I was simply forgotten. Then you nominate your executors and you indicate the power which they are going to have. Then the last you date the will, you sign it, and you give two witnesses to sign and also put their names and address on each page. Now, as I conclude on wills, there is no law which mandates that you must give your children a share in your estate as a matter of law, with the following exceptions. One, you are not allowed to give away your home or your homes where you have been staying with your children and spouses, because those are given to those people by law. Secondly, the only children who can challenge your will on the issue of being not given or being given little are dependent children. Those are children who are minors or children who are adults but they were dependent. For instance, you may have a child who is an adult but of unsound mind, a person who has a mental illness, and that child was totally dependent on you, and then you make a will and not give them anything. So even if that child is an adult, because they were dependent, the person who is taking care of them can go to court and challenge the distribution of your will and say you have not left that child, either a minor child or a dependent adult child, you have not left them enough of your estate to take care of their future needs at and the standard that you had left them. So conclusion, the benefits of making a will is that it reduces disputes that often arise upon death. If you were to go to most high courts in this country, especially except the commercial ones and the criminal ones, the biggest number of matters which are in those courts are land matters or estate matters. Land matters or estate. Even those land matters, most of them come out of estates. So it's a very costly thing. So many disputes come up, especially because of the very difficult matters we have, the very complicated family structures we have in this country. So making a will reduces disputes. Doesn't take them away, but it reduces their chances, because whatever we do in that estate, we must first look at the will. Then it helps reduce costly litigation over your estate. If your children are in court and you left 100 cows and they are fighting over those cows, by the time they take them, their shares will have reduced because some of those cows would have gone to lawyers. Okay, cows may be multiplying, but if I can give another thing which doesn't multiply, uh, let us say they are fighting over two cars. By the time they take the cars, by the time they take the cars, they would have spent more, they would have spent a lot of money on lawyers, and then the time the cars would have depreciated. So making a will reduces litigation over your estate. Thirdly, a will helps in the sense that it is you who distributes your estate, not the courts. It is you who takes charge. If you don't, the courts will distribute it according to the law. Now, under the law, right now we have a share for minors which is 20% if you don't leave a will. But if you leave a will You can even increase that share and say 50% of my estate set aside for my children who are in school. 50% of my estate can be set aside. That's that's power you have when you make a will. So it is you who decides whom you are going to give less than others. You can decide, for instance, that all this estate I made it with my ex. It is only a good thing if I should give her something. Although she left, we sued each other, or we just abandoned each other. But the truth of the matter is that woman and me, we made this money together. So let me give her something. Or you give to spouses, you give to persons in your life who do not qualify under the law to be called spouses. But you are aware that those people have built you, have helped you in certain ways. You give them a share. And you give to people who would not benefit at law. You can give to a church, to a mosque, and that is that. So briefly, as if I can say briefly, that's that on wills. Now, because of time limitations, the issue of trusts, the issue of trusts is very complicated, but in simple terms, you will say that a trust is like a vehicle. You in Uganda, in Uganda, you have several different laws which impact on how to do trust businesses. But a trust is simply, if I can put it this, let me in simple words, because I want to be as simple as possible. It's like a company. It's an institution. It's an entity which holds property on behalf of persons you have named. You have named as the beneficiaries of that entity. So, for instance, if I am buying land, I can buy land directly and put it in that entity. So it's an entity which you must register. I don't know whether I'm still being heard.
Yes, we can hear you,
Okay.
Council.
It's an entity you register. It is registered with the Ministry of Lands and Ministry of Lands and Urban Planning, and you register that name. You reserve a name with the URSB, Uganda Registration Services Bureau. You draft a trust deed, which is a document that outlines the purposes of that trust, the beneficiaries of that trust, the powers and the responsibilities of the trustees. It is good to engage lawyers in drafting a trust. A trust is a more technical entity than a will. So it's good practice that you engage lawyers and they take you through the powers that are going to be held by those trustees. The first trustee may even be yourself. You may also even be a beneficiary under the trust you set up. So then you apply to the Ministry of Lands to register that trust. And you at the end of this process, you will get a certificate of registration of that trust. So that trust becomes a legal person which can own property. So that's why this period of time that I have wouldn't do justice to that. But let us look at it this way. One, you can register a trust in your own lifetime. In simple terms, it's like a company. You register it and you say the beneficiaries of this trust are the following. You name your children, for instance. The income of this trust is this. It can be a trust to hold property. It can be a trust property in the terms of land. It can be a trust to hold money. And that money, you say, it's going to take care of my children in the following ways. It can be a trust you make under a will. So in your own will, you provide that the following properties are going to go into a trust and they will be managed in the following manner. There's a gentleman who made a will with those types of provisions that my youngest child is 8. This property is going to be held. He had a lot of cattle, he had a lot of land, and he said the property is going to be managed and the income will be paid towards the education of my children in the following manners until the youngest child becomes 18. So a trust is both, you can make one when you are still alive and then one when you make it under your will. I think that can suffice for now because of time. Hello.
Yes, thank you so much.
More about trusts.
And also touch the powers of attorney, terms like that.
Powers of attorney. Powers of attorney, there's this letters of administration work in respect of an estate of a person who has died. That's a person who has left no will or who has left a will without naming executors, or where the executors have refused or failed to act. That's letters of administration. Now, many people confuse letters of administration with powers of attorney. Powers of attorney are given to you in the Ugandan context. I know in the West they have developed further, but in the Ugandan context, a power of attorney is a power you give to a person to stand in for you legally, either to manage your affairs, or for instance, I can give you a power of attorney to enable you to go and represent me in court, or I can give you a power of attorney, to go and use my title to pledge it for a loan. So a power of attorney in the Ugandan context ceases to have effect the moment I die. If I give you a power of attorney to collect rent in my houses, you can collect it and you act according to those powers which are to the authority I've given you in that power. It is usually very strictly interpreted by law, but the moment I pass on, the power ceases to have effect. Then the estate goes into administration, into the things we have been talking about, either by will or in the Ugandan context of intestacy under the Succession Act. So that's the difference. Now, a trustee is not in the real sense a hold of a power of attorney, although the trustee's power is given also under a document. But a trustee, if I could say, a trustee is more powerful than a hold of a power of attorney. That's the smallest I can say about that.
Thank you so much, Constable Bogere. This has been very deep and very educative. I'm sure many of us are now having a clearer picture about wills. There are many questions, and I'd like to start off by asking you to further clarify about the witnesses. Does a witness have to know the content of the will? When do they witness this? Do they have both of them to be around or what? And maybe from that point, I would ask Dr. Philippa to take on the Q&A session.
Thank you very much. Witnesses, is a good practice that they should not read the contents of your will, but if they do, it doesn't invalidate the will. Good practice because the example I usually give is that you may find that your best friend is having an affair with your wife. These are estates, these are matters we have actually handled. I handled a matter where the firstborn of a deceased man was the son of his best man.
Okay.
So it is possible that your best friend is having a spouse with a relationship with your spouse. Now, if they read your will, and then in your will you are naming other children which your spouse doesn't know about, and this person goes and says, by the way, your husband or your wife has other children. These children who have been calling your husband or your wife auntie or uncle are actually his children. So it's not good for people to know those things because they may affect even the speed at which you go. Secondly, the witnesses don't necessarily have to be present at the same time that you are signing the will. The term there is a bit confusing sometimes to people. They think that the witnesses must actually see you sign. The law says the witnesses must see you sign or receive an acknowledgement of your signature from you. So a witness can come when I've already signed my will. And then I tell them that, by the way, the reason I called you today is I want you to be a witness to my will. I have signed it here. Please sign for me here. And that witness then signs each page. So it must be a person you absolutely trust who can sign a document without saying, let me read through. And even when we are asked to sign, am I sure that I'm not signing a sale agreement for my land? You put there me as a witness, and then you sign. I've also seen some questions here that can executors be changed after the deceased? An executor is named by the deceased, by the make of the will. So any other person who is not named in the will cannot be called an executor. But if an executor misbehaves, if they mismanage the estate, if they are lazy towards handling estate matters, they can be challenged in court and they can be removed. And another scenario is that if the executors fail to go to court within 1 year to apply for probate, if they fail to go to court to apply for probate within 1 year, the beneficiaries can apply for letters of administration with that will annexed.
Thank you, Counsel. I'm going to invite you to actually go through the chat. There are several questions. You have addressed one of them.
Thank you.
I've
seen one which says, is there an algorithm?
Yes.
Is there an algorithm to pick executors? Because people can be good hypocrites. That's what I said, by the way, and that's the truth. There is I give these examples because that's what happens. There's an estate where a cabinet minister was the chief guest at a customary wedding of a couple. Chief guest, and he was a lawyer, that cabinet minister, and he is on video saying This is a customary marriage. It's a legal marriage in our country. You are man and wife. Then, after like 10 years, the man dies, the husband. The cabinet minister tries to have a relationship with the widow, and she refuses. The cabinet minister starts a war against the widow and starts saying she was not married. When there's a video of him saying the opposite, just because she has refused his advances, and he goes and transfers the deceased's land into the names of the mother of the deceased, because he's fighting this woman who with her two small children. So imagine the deceased could have left a will naming such a person the executor of the will. So another instance, or another estate we handled was over an advocate, a lawyer who loved one of the widows, and he disinherited the other children of the man. They are now driving borders, a very wealthy gentleman. So the people you choose as administrators, as executors, in all honesty, you may need an algorithm, because I doubt even if algorithms can also work on people, because algorithms are again made by people. Uh, Perhaps that lawyer's mistake was to deliberately defraud his brother. I don't know what that one was.
I
Oh,
think that was
I
in
think he
a
was speaking
comment
about
to your.
yes, I think the one of the brother who had a unsound mind.
Yes. Mm.
It was a very complicated estate, that one, and it went to court. Uh,
I think the next question is from
that
Salongo, asking if there's a particular format in which a will can be done. If yes, is it possible to have a copy or template?
there is a format within the law. I will share a format. There's a format, but I wouldn't advise people to go by it, because it is very restrictive. And people tend sometimes to think that they should just fill in things. So wills are supposed, a good thing is be descriptive as possible without going overboard. But the format will be shared. Can you explain why
Okay.
we need to put on titles if have you have to go to other people? What is the alternative to having a joint tenancy? Uh, if you want half of your land to go to your beneficiaries, you need to register what we call a tenancy in common. The law says there are three ways of owning property. You can own it as a sole proprietor. The title is only in your names. As a joint tenancy, the title is in your names and other people, but that one means any one of you who dies, their share doesn't go to their estate. Their share ends on death. Then there's a tenancy in common. Tenancy in common, the shares survive you, the maker, sorry, the owner. So you can have a property, for instance, registered in three people's names. Robert, that's one person. Ali, person number 2, and Bogere, person number 3. That property title can even say Robert 30%, Ali 30%, Bogere 40. So it makes 100. So if Robert dies, his 30% share survives him and it is inherited by his family. He can even make a will giving away that 30. But if the title simply says Robert, person Bogere, Ali, and then it shows 10 acres, all of them, any one of you who dies, your share ends there. Even if you have a home on it, the others take. So the alternative to having a joint tenancy is having a tenancy in common. Uh, then, if a child is not named in a will as a beneficiary, i.e. secret child, can that child be entitled to the property? That's an issue I tried to discuss before, that if a person is not named in a will, the danger for you not naming that person in a will is that that person can go to court and challenge it and say, I was forgotten, something like that. One of the tests for a person having capacity is that that person has a clear memory, a clear understanding of his closest relatives. So if you make a will, for instance, and you don't name, you say I have 5 children when you actually have 10. I have 5 children when you actually have 10. Someone can interpret it and say the deceased, the testator was not in control of his mind because he did not have a clear understanding of the persons whom we say ordinarily his natural who would have his natural affections. So it can be interpreted that you simply forgot that child, or that you had mental issues that you forgot your children. So it is good practice to name your children. I don't know why people fear. After all, this will is going to come out when you're already dead. You don't have to fear your spouse. You name all the 10 children you have outside wedlock, and make sure that your spouse doesn't read your will before you die. There's nothing reason why you say secret child. So if that child is not named, the child can challenge, especially if that child is a minor. That one is an automatic that that child will have to get a share from that will. The courts will alter, will make alterations in your will and.
Counsel, we can't hear you very well now. Your volume is very low.
Thank you. I was saying that if a child is not named in a will, that child can challenge the will and have it varied, especially if that child is a minor or was a dependent on the late. But in some circumstances, it can even be interpreted to say you had no control over your mental capacity, that you forgot your children. I've seen wills where a person did not list 5 children because he was angry with their mothers. So now, a person can challenge it and say, if you did not even know your children, you had no capacity to make a will. Another question is it okay for grandchildren to sell a family house of their grandfather? Uh, the simple point is that grandchildren have no share in the estate of their grandparent. Grandchildren have a share in the estates of those who give birth to them. It is those who give birth to them who have the share in the estate of the grandfather. So if I can put it this way, my children have a share in my estate. My grandchildren have a share in the estates of my children. So for grandchildren to come and sell the estate of their grandparent, they must have powers of letters of administration for the estates out of which they come. A grandchild is not a direct beneficiary to the estate of the grandparent, except if there is a will giving them. So let us consider that estates are distributed. If there's no will, they are distributed at the level of the first line beneficiaries. That's children. Each child's children share in the share of that child. They don't share directly in the estate of the grandparent. Can beneficiaries of a will be executors? Yes. An executor can be in the beneficiary to the will, but still that executor should not sign the will as a witness. The share which is given to a person who is registered, who signs the will as a witness, the law considers as if you did not give that property to someone. So that property will be shared according to the law of intestate succession. So if I give my son 10 acres of land and then he signs as a witness, the law will say that the deceased did not give that 10 acres to anyone. That 10 acres will be distributed in the formula of 20% for the surviving spouse, 75% for the children, including the children who took their other shares elsewhere in the will. Unless they forgive you and say, okay, this was your share, let us give it to you. But if they insist, they will share in it because it is not your So I'm thinking of another question, that what about 20% mandatory for children? That one doesn't work in wills. It works in an estate where a person left no will. The law says when you leave no will and you have children who are below 18 or children who are above 18 but they were dependent on you fully for their for their sustenance. For instance, you may have children who have mental health issues, or you may have children who are incapacitated to such an extent that they can't take care of themselves, or children who are going to school. That child is entitled to a maximum of 20% to take care of them until they are out of school, or until they get to 25 years of age, or until they get married. So that 20% is a reserve. It's not a distribution, it's a reserve. It's like an insurance cut off to take care of, but it's a maximum. The example I usually give to people is that in the estate of a person like Sudil, 20% of his estate is too big to take care of the school going needs of children. So in that estate of a person like Sudil, we can need even like just 1%. So 20% is looked at as the maximum. And after the children stop going to school, or they get married, or they reach 25, the property out of which that 20% was being extracted, that property is brought back and distributed to all the children. So in an estate where they are minors, before we distribute it, we first take off a maximum of 20%. We first take off a maximum of 20%. Do trusts pay taxes? And if so, how do you minimize taxes? In this country, the tax regime on track on trusts is a, how do I call it, is a all over the place. If you buy property directly into the names of a trust, you will pay taxes at that level of buying the property. But a trust transferring property to a beneficiary, there is no tax payable at that level. When you are transferring property, even from administrators to beneficiaries, you don't pay tax in the sense of you pay registration fees. So how do you minimize taxes? The best thing to do is to buy property directly into the names of the trust, so that you don't buy it in your names. If you buy it in your names, then you transfer it to a trust. You will pay tax at the time you are buying it into your names. Then you'll also be paying tax at the point of transferring it into the trust. So you'll be paying double. So the best is buy property directly into the names of the trust. If someone passed, can they open a trust for the family? Yes. Decide that instead of us distributing the property and consuming it, let us transfer it into a trust so that we get income from it. Property which is in the names of the trust, the beauty of the trust is, let us say I buy apartments and put them in a trust. That property is owned by the trust but not by my children. So my children's share is the income which I give them in the trust deed, in the constitution, if I can call it that way. I say each child who is below 18 will be entitled to 2 million per month. So their only interest in that property is the income from it, but the powers to deal with the property are in the names of the trustees, and the owner of the property is the trust. So children, a family can sit and own and do a trust. What's the difference between a trust and a company? A company, if I can put it this way, a company is a trust is a form of also a legal person, but not a a company. The owners have shares in it. The the. I'm sorry, someone is saying things, and I hope it's okay. Uh, a company and a trust is a vehicle which is a trust actually can also be a company in a sense, if I can put it that way. But companies, there are so many things which companies can do which trusts are not allowed to do. There are so many, the shareholders of a company actually own. The shareholders of a company actually are the owners of the company, if I can put it this way. But the trustees are not necessarily the what? The owners of the company. I'm rushing through because of the time elements. What are the benefits of making a trust? One of them is tax issues. Secondly, a trust is a better way of handling matters. If you, for instance, you want your legacy to be maintained longer. Why? As I've said, the trust owns the company. The beneficiaries, your children, are only entitled to income from it. Although ultimately, your children can still sit, depending on what powers you have given them. When the trustees all pass on, your children can still sit and deal with the property, but it will be a more difficult process for them to dispose of your property, as opposed to a will. When you make a will and you give property to people, you are giving each property in their names so they can deal with it, whatever. You can't, for instance, like most Ugandans do, make a will and say, whoever sells my property will see me. This is a very common proverb, provision in Ugandan wills. Whoever anabitunda anandaba in Uganda. But in that's property you have given to people, you can't curtail their enjoyment of that property. But in a will, sorry, in a trust, you can provide that this property is going to take care of the following people until they are 18. This property is going to take care of the following people, and you're going to use it to build to again build another property of the following value. So you can do a lot of planning and extending your legacy in a trust as compared to a will kind of estate distribution. When making a will, who should be present and who is allowed to be present? Anyone can be present in making a will, but it's not good to make it when the direct beneficiaries of that will are around. Have your lawyer, have the witnesses who are going to be witnesses to it as the people present when you are making the will. Is it legal? Is it is it legal? Is it legal for the family to be at home when they're making a will? There's nothing wrong with them to be there, but don't let them be witnesses to that will. Let me first open these things because they are not.
I think that question is saying, let me just read it to you. Is it legal for a family home when the will is being made by the husband to be left in the names of the wife only when she lives in it, I think?
Oh,
Yeah, it's left is if it's left as a property which she can also have a right to
okay. Yeah, I said
also
before.
include it in her will in case her husband dies before her.
Yes, I was actually I did not I was not looking at it properly. Now, in essence, I said before that in your will, you are not allowed to distribute your homes unless you have left alternative accommodation for your spouse and for your children. So if you want to leave property to your spouse alone minus the children, you have to make sure that you have left the children also something. Don't get property and leave it to only the spouse, or don't let don't let the matrimony, the home, the residential holding, and you give it to only the spouse or only the children. The best thing, the best thing is give it to both of them because that's what the law does. You are not allowed to give it to the spouse alone. It is a very sad thing when you have an estate where there are minor children, for instance, and the deceased left property and gave it to a new spouse. Let me put it that way. A new spouse who has entered his life, and that new spouse is not the mother to these children. So the law wanted stability in that home environment for wherever has been staying there. Let them continue staying there until the law says you are no longer allowed to stay in that home. For instance, for a child, you are not allowed to stay in that home until, sorry, when you are above 25 if you are not going to school, or when you are married if you are above 18, whichever is younger. If you are 18 and get married, the law doesn't give you a mandate to stay in your parents' home. If you are 25 and still going to school and unmarried, you can be allowed to stay there if you are staying there during the lifetime of the late. What happens when an executor also dies shortly after the will, but before the element of the will have been executed? What can the beneficiaries do? If the executor dies, beneficiaries can go to court and apply for letters of administration with the will annexed. They bring a death certificate of the executor to court. So they will go through the process of going to the administrator general and applying for letters of administration. What happens if the executors die before me? That means in your will, you have in your will you have basically the people will apply for letters of administration without with the will annexed because they will not be executors. Alternatively, if you are aware that your executors have died before you, you can name new executors by drafting another document called a codicil, and you say in my will I had named Bogere to be my executor, but now he's dead. I now name Robert as my executor. So that codicil is also in the same format as a will. Must be, the codicil is in the same format as a will. It must be dated. It must be signed by the maker. Is on the will, but it must also have two witnesses to it. I'm sorry, someone he wants to see me, but must the codicil be witnessed as the original to be valid? The codicil must be witnessed by at least two people, but they don't have to be the same as the ones who witness the will. Is obtaining a certificate of no objection a requirement for people with properly drawn will? Yes, if the will doesn't have executors. If the will doesn't have executors, you must obtain a certificate of no objection. Secondly, if the executors are, or maybe they are dead, you must also obtain a certificate of no objection. Or if the executors are not willing to act, or they have not applied for letters of administration within 1 year of the death of the maker. Can one have an addendum to the will, or do they need to rewrite the whole thing? And do you have to call the first witnesses to sign, or can you have another person? That's the same question I've answered. You can have an addendum to a will, which is they call a codicil, and you don't have to call the first witnesses to sign. If one makes his will without witnesses but signs it, is it valid? No. The will cannot be valid if it is not witnessed. What is the procedure of changing from joint tenancy to tenancy in common? Someone is already afraid. Both of you can issue a transfer. The two of you who are on the title can sign a transfer to yourselves. Robert, one person, and the Bogere who are on the title as joint tenants can sign a transfer to Robert and the Bogere as tenants in common in equal shares or in the following shares. So it's a simple process, but you'll pay tax stamp duty on that. How come we don't see joint tenancy or tenancy in common in our titles? Where is that registered? If your title is silent, you are a joint tenant. If your title has, for instance, Robert Bogere and James Okello, and it's silent, it means automatically you are a joint tenant. The one of you who dies first, your interest ends there. The property becomes that one of the survivor. So if you want to change it, you need to go to land office and issue yourselves a transfer, as I've said before. Easements, rights, and easements and other rights. For instance, you can have a title where there's a right of way for other people. You can have a title where it is a known fact that they are lines passing over it. How do you call it? Which has water mains, which has sewer lines passing over it. So that's whoever buys that land, it is subject to the fact that others may have a right to use those things. You cannot stop them when you. If my grandfather dies, but my father died before him, do I still have a share in my grandfather's estate? If your father died before your grandfather, and your grandfather left no will distributing the property, automatically your father has a share. In any estate where a person dies before their father or their mother, but that person leaves children, the predeceased person is given a share. If I have 2 children and one dies before me, but that child who has died before me leaves children of his own or her own, when I die and I have left now one child surviving me, when my estate is being distributed, if I have left no will, even my dead child who died before me will be given the same share as the living child. So you as a grandchild, you don't have the share. It's your dead parent who has the share. And it is an equal share in case there is a will. It is the same thing even if your father was given a share in a will but died before his own father. The law says the law only protects actually that a widow. So if I marry another woman, the children of my first wife who died cannot come and say our mother was also your wife at one point. No. The only people who are allowed for their successors to take land in my estate if they have died before me are children. Who die before me will have a share who survive me. So yes, you have a share. Sorry, your father has a share. It is not you who has it. Must witnesses read through the will? No. Must they retain a copy? No. Where a man has many relationships, do all women, including those he has not been catering for, are they entitled to his property because he has children with them? No. The only people you have responsibilities for, if I can call it that, whom you must forward see when you are distributing your estate, are spouses who are married to you lawfully and your children. Any other person, any girlfriend, and, and the rest are not entitled to you taking care of
Sorry,
them
Kans, I think
as
you're
them.
breaking up.
You must take care of
You-
her,
We
dependent
need
on
to
you in the sense
repeat
of she
that.
was under your maintenance and we are sure that the child is yours, we are not going to. Sorry, I was saying, I was saying if you leave a child, a woman who is carrying your child, to take care of this woman until she has given birth. The law says, putatively, you are the father. Let us take care of this pregnancy, and when the child is born, hello.
Yes, we hear you now. Hope it will be
Okay,
clearer.
okay. Sorry, I was saying that if you have left a lady who is pregnant, and we cannot take the risk of saying that let us leave that child and to suffer the pregnancy, to suffer until it is born. It's good for that child to be taken care of, and we'll handle the rest after your what? After we can prove whether or not the child is what? Is yours or not. We will not let the child suffer. Can a will be drafted while in diaspora be buried in Uganda? Yes, it is. It can be enforced even here. Can one put a caveat on your property, and can it be sustained after one dies? Yes, you can put a caveat on your own property. But after you pass on, family members can remove it because they are too greedy, as you say. Your children can remove it when they get letters of administration. What is the equivalent of 20% for the legal wife? That one depends on the estate value. Take the estate as 100%. 20%, if it's 100 cows, 20 cows are the ones you take off. How much power or ownership of property from the grandchild that children, the grandchildren whose parents are dead get? The grandchildren don't share. It's their parents who share, and their parents have the same share as the living children. So all children have the same share. Can I leave property to a church? If I leave property to a church, I must store the will in a place approved for what year? Which places are those? The places provided for under the law is the court. It seems only men are meant to die. What happens when a witness's will dies? It is true, only men are meant to die. Uh, that's a joke, but it's a fact that women outlive us, and it's because usually we marry them when they are younger than us, and then we take more risks as men. What happens when a witness dies before the proprietor? There is nothing wrong. A will can be proved even if the witness are dead. A will can be proved if the witnesses are missing, or the witnesses deny that that's their signatures. They are supporting one of the groups and they want to invalidate them, even if the witnesses denies their signatures. So the 20% goes to the children. What is the difference between a trust and an estate? That one I've tried to give it. If I pass that 50% of my share, will it go to an estate opened for my child? If I leave on my will something saying if I pass, 50% share of my property will go to an estate opened for my child, that one is okay. It's allowed to a trust opened for my child. You can do that. In case a wife builds a family home together, as in contributing equally with the husband, is it in order for the husband to leave it to the wife? Hello?
Yes, we hear you, Counsel.
Yes. The law on contribution to the house you live in is difficult, because in estate matters we distribute the property which is in the names of the dead person. So if you contributed to the building of that home, unfortunately, when we are distributing an estate of a deceased person, we don't look at who contributed to what. Because on the other hand, if you married a man today and he died tomorrow, you are also getting 20% of things you never contributed to. So the law on the estate of a dead person doesn't look at contribution. Is it in order for the husband to leave it to the wife? No. Unless he leaves to the children something else which they are going to call their home. Is it legal to distribute inherited property to minors? Yes, it is allowed. How do you handle a lawyer who tries to hide information in a will from the beneficiaries? You take them, you either go to the administrator general or you take them to court, and you can compel them, or to the law council, which handles disciplinary matters for lawyers. Can I transfer my joint share to another person in my will of the dead child in a will? Do the children of the child who died before the father have a remedy? Unless they were dependent on the grandparent. Unless they were dependent on the grandparent, that is when they can have a remedy. And they say our grandparent, we were dependent, but they cannot sue that why didn't you give to our dead father? That one is not possible. Can I inherit my mother's property when she dies? Yes. The parent, the property of a deceased woman is under the same law as the property of a deceased man. The deceased woman's husband will take 20%. The children of the woman will take 75%. Usually people think that the woman's property is for the people of her father's clan. No, it is also for the property of her husband and her children. And you, the relatives of her from her, the heir from her father's clan only gets 1%. Can you distribute property in joint tenants land? No. If at your death it goes to the remaining person on the title, you cannot. It only remains the property of the person on the title. Is it legal to subject children of the late for DNA tests when the deceased named them in his will as his? No, it is not. Unfortunately, in our country, we don't have a law which mandates DNA testing. So, it is very troublesome that DNA testing has become like a tool for people to beat each other with. But if the deceased person left no reason to doubt their children, then who are you to come and doubt them? So if the person left children in his will as his, the presumption is that they are his, and there is no law which mandates someone to say, we need to test them. I'm still confused. If the law says a child predeceases the parent, the child is entitled to a share. No, that's not true. Under the law, if a child predeceases, the child has a share if that child leaves children of their own. If the child leaves no children, they don't have a share. For instance, if I die before my father and I leave my wife, I don't get a share. But if I die before my father and I leave children, my children must survive my father. So that my father, when he dies, his grandchildren, who are my children, are alive. So I am given a share, and my share is taken by my children. So in the position is different. Sorry, the position is for this is the same whether there is a will or not a will for children. The only other category of people who are disinherited are the others. If there was a wife, if she dies before, she doesn't get a share because she's not a widow. If they are dependents, if they die before, it means they were not dependents on the day the deceased died. If they supposedly the person nominated to be the heir dies before the deceased, he was not the heir because he did not survive. But for children, whether they survive or they don't survive, if they leave children of their own, they are given a share because the law considers blood as a different category of beneficiaries. What if someone dies intestate and his daughters equally distribute a piece of land to themselves in a family meeting and finally sell? Can an administrator, because he demands for money which wasn't given to him, successfully challenge the sale? No, because ultimately an administrator is managing the property on behalf of these daughters. So even if he challenges the sale, he will still have to give those daughters that very same property and they again sell it. So an administrator is not the owner of the property of a deceased person. He is only representing the beneficiaries, who are the ones who sell. What happens when there is an ongoing divorce in court but a spouse dies and leaves a will? Can the surviving spouse be regarded as a wife? If there's a divorce, I am only assuming, I assume that those people are separated. If the man dies or if the wife dies, in this case you say if any of them dies, the surviving spouse who was going through a divorce can go to court and apply to court and say, I need to be considered a spouse, and he gives reasons, which can be that we were divorcing because my husband was beating me. So we were separated because he was beating me. Let me give a scenario which is happening, the scenario of Bujingo. If Bujingo were to die now, they are going through a divorce. Assuming Bujingo has left a will giving his property to Makula, his girlfriend now. The wife, Teddy, can go to court and say, the reason we were going through a divorce was because my husband wanted to marry another woman, but it's not because I wanted the divorce. So Bujingo is the one who caused the separation. I'm giving a scenario just. So in that case of the case you are giving, if the surviving spouse gives reasons which are showing that the separation was caused by the other dead person, the court will give them a beneficial interest. The network is so unstable. Is it possible to get a written document? They will give you a recording. Must the heir be assigned a portion of the property? If there is no will, the heir gets 1% of the property. What types of marriage are formally recognized? Is a second and third wife considered? In Uganda, we have customary marriages, which you can marry more than even billions of wives. Everyone will be considered as long as they were married customarily according to the customs especially of the wife. What types of marriage? Customary marriage, church marriage, which is a monogamous marriage under the Marriage Act. It's a church marriage. We also have a civil marriage, also monogamous, one man, one wife. We have Muslim marriages, which are restricted polygamy, up to 4 wives. We have Hindu marriages, and then we have marriages of foreigners, as long as they don't contradict the marriages of Ugandan law. For instance, Elton John's husband can't come here and claim that he wants a share as the widow of a man can't come here in Uganda and claim to be a widow of a man, even though their marriage is recognized out of the country. In this country, it will not be allowed. But if the foreign marriage is not contrary to Ugandan laws, it will be recognized. The caveat is that for you to be married in certain marriages, there are restrictions. For instance, you can't be customarily married if your husband already had another wife who is still alive and they are not divorced. And that wife was a church wife or a Muslim wife. So don't mix these types of marriages unless you are marrying the same person. If it's a customary marriage, be married only customarily. If it's a church marriage, you can't mix it with Muslim marriages and customary marriages. If it's a Muslim marriage, you can't mix it with civil and Muslims. So stay in the same law, because these marriages which I've spoken about all have a law which governs them. So as long as you are married, you are considered. From what you are saying, wives should buy property in their names, otherwise getting 20% is not fair. That is true. Can a trust be challenged in court? Yes, everything can be challenged in court. If the children of the deceased were dependent on the grandparent, but currently are above 25, but their parent not the children of the dead, were named in the will, do they have a remedy? If they were dependent on the grandparent, but they are currently above 25, dependency ends at 25 or marriage. So if you are 25, you cannot be a dependent, whether you are married or not. But we don't look at the date now. We look at the date they were when the grandparent died. If the grandparent died when they were dependent, they can still sue. We don't look at the date at when they want to lay their claim. For instance, it's the same thing if I die now, my wife's share falls into place now. If she marries later and my estate is distributed when she's married, she still gets the share of when she was my widow. The fact that she's now married doesn't change the fact that she was my widow on the day I died. So if these grandchildren were dependent on the day of death, as in they were below 25 and unmarried and going to school, for instance, it doesn't matter that by the time the estate is distributed, they have become old. Their shares will be given to them because their shares fell into place on the day of death. Can an administrator administer property which was never included in his application for letters? Yes, they can. The property of a deceased person is the property of a deceased person. It doesn't depend on applications or petitions. Even if it is not in his or her will, that property belongs to the deceased person, because in a petition for letters of administration, ownership of property is not an issue. What is at issue is to administer the estate. So even if property is discovered later, it was for the deceased. The issue is, was it his property? Why is buying property in their names will trigger a third world war in the family? I think those are the questions I have managed to get. Thank you very much.
Thank you so much, Council. Those were very many questions. I think it's clear that people needed this session. Thank you very much. There's one question that came into my inbox earlier. I just didn't want to interrupt. It's about the family home after parents pass on, especially adults above 18 and married who are no longer staying there. Like, what happens to the family home when the parents have both passed and the children are above 18 and married and not staying at home?
Thank you very much. The property, the law gives it to all the children equally. So it is for them to sit down and say, we can sell it, we can convert it into rentals and get income from it, because it is their property. None of them, not a single one of them, can determine what to do with it. So you need the children to sit and decide what they can do with it and vote on it, because all of them, they have the same share. So you can say, if one wants to keep it, you can tell him, buy it, buy us out, buy all our interests out. If one of them wants to, if one of them wants to sell their share, he can sell to any other of the children. Basically, that's that. Thank you very much.
Thank you very much, Council. This has gone on for much longer than we thought, but I think it was important that we answered those questions. I'll hand back to the moderator to close the session.
Thank you so much, Dr. Philippa. Council Bogere, on the very last question of the homestead, is that pertaining to person who died without a will, or a person who willed it to someone, to one of their children?
Thank you. If a person dies, we have seen that that the general rule is that you are not supposed to distribute your home, because it belongs to the surviving spouse and children. So that's the general rule. But in case you want to distribute it, you must give these children and your surviving spouse an alternative. So I say it is either way. If you have distributed it, it means you have given these other children an alternative property, which is going to still be the same property we are talking about, property belonging to. So if you have given it to someone and you have given others another property, then it belongs to only to that person you have given that particular property. What we would be discussing then is the other alternative property you have given to the others to substitute for the home you have given to the one child. I don't know whether I've come out clear.
Yes, it's very clear to me at
Yes.
least.
So we will still have a home for all of them. So the home for all of the children belongs to all of them, and they can only deal with it if they have made a joint decision. None of them can do it themselves. Thank you very much.
Thank you so much, Councillor Bogere. And I want to thank all of you who have attended up to the last minute, who have interacted with so many questions. Clearly, we need to have more and more sessions to make sure that all of us are on the same page. There have been questions from people who had property in different jurisdiction. I think we have touched it, but I think there are more questions in that area. But we are very grateful that you made this session and simple and understandable to the common man, not to learned friends only. I want to ask all of you to give a clap to Councillor Bogere, and also remind you that on the last Saturday of Feb, we shall be here once again and have a session to do with cancer. Please do attend, because this affects us as old adults and the caregivers in the various categories. Thank you so much for attending, and have a very, very wonderful session as you prepare your wills starting from today. Each one of you who has been here, please take the step. It does not mean you are dying tonight. It's just making sure that your wishes will be dealt with as you actually wish. Thank you so much, everybody. Let's give ourselves a clap. Thank you and bye.